This video is not legal advice. It is for educational purposes only. It does not create an attorney-client relationship. Always consult a qualified attorney for advice specific to your situation. For the last 350 years, sovereign authority has denoted the supreme, independent, and exclusive power of a state or political community to govern the conduct of individuals and defend rights in personal and real property within a defined geographic territory. This authority is limited only by the correlative duty to refrain from interfering with persons, things, or activities beyond the territory. Sovereign authority is thus closely tied to jurisdiction, from the Latin jurisdictio, the power to speak the law. It encompasses the sovereign's power over litigants and the resolution of their disputes. Traditionally, this power has been delegated to judicial officers who constitute courts that derive their jurisdiction from the sovereign by constitution, statute, or custom. In American courts, jurisdiction is not raw sovereign power. It is the concept of a juridical sovereignty that is prudently exercised to avoid gratuitous intervention in private affairs. It is also an organizing principle that rationally allocates authority among the states and between states, and the constitutionally limited sovereignty of the federal government. Jurisdiction is thus a composite concept whose nested and interrelated components delimit the exercise of sovereignty over disputes and litigants, and delimit the sharing of authority between courts and court systems. Its primary component is fundamental jurisdiction, which is itself composite. A court possesses fundamental jurisdiction only when both subject matter jurisdiction and personal jurisdiction exist. A court acts in excess of its fundamental jurisdiction when it fails to observe the prescriptions of subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction is the court's authority to hear and decide specified categories of disputes based on the nature of the claims, the amount in controversy, or the alleged public offense. It inheres in the court as a whole and not in any individual judicial officer or department. That said, courts may have subject matter jurisdiction in degrees, or what are known as limited subject matter jurisdiction and general subject matter jurisdiction. Courts possess limited subject matter jurisdiction when their authority is restricted to adjudicating certain kinds of disputes, such as probate matters, marital dissolutions, criminal actions resulting in light penalties, and civil actions involving relatively small sums of money. Courts possess general subject matter jurisdiction when they have authority over a broad array of disputes. But, regardless of its scope, subject matter jurisdiction requires an actual, or ripe, dispute between parties with genuinely adversarial interests. Academic or hypothetical controversies yield only advisory opinions, which courts properly reject as imprudent. Similarly, courts dismiss moot cases, those resolved by intervening events unrelated to the litigation, as non-justiciable, since no effective remedy is possible. Furthermore, when a court lacks subject matter jurisdiction in a case, its judgment is void ab initio or null from the outset, a nullity that cannot be cured by waiver or consent of the litigants. A court must dismiss on its own motion, or sua sponte, a case over which it has no subject matter jurisdiction, and it must do so at the earliest opportunity, which is normally at a hearing on the sufficiency of the pleadings. The other component of fundamental jurisdiction is personal jurisdiction, or jurisdiction in personam. Personal jurisdiction is the power of a court to bind a litigant personally to its rulings. A court may render judgment against a defendant only if it has personal jurisdiction over the defendant and due process is satisfied. Namely, 1. The defendant falls within the court's sovereign authority via traditional bases or constitutional minimum contacts. And 2. The plaintiff has realized valid service of process, affording the defendant notice and opportunity to be heard. Personal jurisdiction differs from in rem jurisdiction, which is the power over the status of a thing or property, and quasi in rem jurisdiction, which is a hybrid power reaching only a party's unique interest in specific property within the territory. When a court has in rem or quasi in rem jurisdiction over legal disputes, personal jurisdiction is often unnecessary, since those disputes result in judgments that affect only the supporting property, not the owner's person. In rem or quasi in rem jurisdiction exists in cases when disputed properties lie within the court's territory, are properly within the court's actual or constructive possession by means of legal attachment or seizure, and process has been served. Examples of such cases include eminent domain, forfeiture, probate, marital dissolutions, quiet title actions, and lien foreclosures. While these arcane jurisdictional distinctions remain valid, their significance has diminished with the evolution of personal jurisdiction doctrine. Today, personal jurisdiction over litigants exists chiefly under traditional bases or minimum contacts. The traditional bases, which are presumptively constitutional, include 1. Residence or presence in the territory at the time of valid service. 2. General appearance in the litigation. 3. Explicit consent. And 4. Circumstances supporting in rem or quasi in rem jurisdiction. In practice, these often reduce to enforcing forum selection clauses or serving a defendant who is present within the territory. Valid service is thus essential. Defective service renders a civil judgment void for lack of personal jurisdiction, even with actual notice. Prescribed service methods include personal delivery by a qualified process server, substituted service after diligent attempts, along with follow-up mailing, and, as a last resort, service by publication upon court order. These methods satisfy due process by providing notice reasonably calculated to inform defendants they are being sued and providing defendants an opportunity to respond. They are not, however, generally effective outside the court's territory. Both valid service and personal jurisdiction, in general, may be challenged by defendants in court hearings that are called special appearances. Many defendants, however, forego the challenges because dismissal is typically without prejudice to plaintiffs reinitiating actions before the running of the statutes of limitation. Against absent non-resident defendants, traditional bases of personal jurisdiction are often inapplicable. Personal jurisdiction thus requires certain minimum contacts with the territory such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice, as held by the United States Supreme Court in the International Shoe Company. Versus Washington decision. Minimum contacts support either the exercise of general personal jurisdiction, which requires substantial, continuous, and systematic contacts rendering the defendant virtually domiciled in the court's territory, or the exercise of specific personal jurisdiction, which comports with fair play and substantial justice because of dispute-related contacts involving purposeful availment of the territory's benefits. General or specific personal jurisdiction is enforced by states through their long-arm statutes. California's long-arm statute is Section 410.10 of the Code of Civil Procedure. Section 410.10 is expansive. A court in California may exercise jurisdiction on any basis consistent with the state and federal constitutions. Still, service of process on absent non-residents must comply with applicable law, including the Hague Service Convention for Foreign Defendants. When a non-resident defendant challenges a court's general or specific personal jurisdiction, the plaintiff carries the burden of establishing the requisite minimum contacts by a preponderance of the evidence. But the minimum contacts analysis is not satisfied by rote or mechanical demonstration. Courts must weigh the unique facts of each case, as they do with corporate officers, directors, agents, or employees, who do not automatically fall within the scope of the personal jurisdiction binding the corporate defendant. Any defendant who intends to challenge a court's personal jurisdiction, but who also seeks relief on any basis other than lack of personal jurisdiction, has made what is called a general appearance. Since a general appearance is deemed to be an implied consent to the court's personal jurisdiction, Such a defendant waives any objections to personal jurisdiction and defects in service of process by making a general appearance. As noted, when both subject matter and personal jurisdiction exist, a court has fundamental jurisdiction over the legal dispute and the litigants. A court cannot properly refuse or divest itself of fundamental jurisdiction. Additionally, if a court acts without fundamental jurisdiction, its actions are subject either to direct challenge on appeal or to collateral attack when any attempt is made to enforce them. Once established, fundamental jurisdiction endures until voluntary dismissal or final judgment, with the court maintaining the limited post-judgment authority to decide costs, fees, or judgment renewal. Fundamental jurisdiction also makes the court's procedural irregularities voidable but not void. The irregularities are enforceable unless successfully challenged. Beyond fundamental jurisdiction, courts also have jurisdictions that define their roles or hierarchical functions within the American judicial systems. Courts can thus exercise either original or appellate jurisdiction, or some courts exercise both, as in the case of the United States Supreme Court. Courts of original jurisdiction are typically trial courts, which receive evidence, find facts, apply law, and thus create the initial record of litigation. Original jurisdiction does not lie with the trial courts when other government branches afford individuals effective administrative remedies. When administrative remedies exist, their exhaustion is often a prerequisite to trial courts asserting their own original jurisdiction, given the division of sovereign power among the different government branches. Failure to exhaust administrative remedies renders the legal dispute unripe and thus denies the trial court jurisdiction. By contrast, courts of appellate jurisdiction review lower court decisions for legal error, generally deferring to the lower court's factual findings. Appellate jurisdiction is perfected through mechanisms such as direct appeal, certiorari, writs, for example, mandamus and habeas corpus, as well as supersedious. Once perfected, appellate jurisdiction divests the lower court of power over matters affecting the appealed judgment or orders, thus preserving the higher court's jurisdiction and preventing the lower court from rendering the appeal futile. Courts may also have exclusive or concurrent jurisdiction. Courts have exclusive jurisdiction when they are the sole authority over certain disputes, such as disputes over bankruptcy and patents. Courts have concurrent jurisdiction when they share authority with other courts, as in many federal question and diversity of citizenship cases. Ancillary to all these components of jurisdiction are the concepts of venue and forum. Venue is a specific geographic division of a court system, such as a county or a federal district. Forum is a specific institution or tribunal. Forum and venue are significant for purposes of litigation because actions are classified as either local or transitory. Local actions are restricted to the location of, for example, disputed real property. Transitory actions, such as personal injury cases, may be filed anywhere the defendant is subject to service of process. For transitory actions, proper venue and forum are generally the court located where the defendant resides or where the dispute arose, subject to transfer under the doctrine of forum nonconvenience, for the sake of convenience or justice. Neither venue nor forum overrides fundamental jurisdiction. Both are generally waivable by the parties and may be prearranged by contractual forum selection clauses. Once questions regarding jurisdiction, venue, and forum are resolved, courts must resolve choice of law questions. State courts generally apply their own procedural law but honor contractual choice of law provisions for substantive law, unless doing so would violate strong public policy. Further analysis of this topic, however, is beyond the scope of this discussion. As for this discussion, its exposition of jurisdiction, venue, and forum has been from the perspective of the courts. The order of exposition would be different from the strategic perspective of experienced litigators. Experienced litigators first identify the venue that observes the substantive law most favorable to their client's dispute. They then identify the forum that offers the most advantageous procedures, decision makers, and calendar conditions. Once these are settled, Experienced litigators navigate the jurisdictional hurdles, the removal risks, and the forum non-convenience motions. They basically forum shop, although within the bounds of professional ethics. Forum shopping in California often involves leveraging concurrent jurisdiction, favorable state rules, and sympathetic juries against potential transfer or federal removal. The specific rules governing the jurisdiction, venue, and forums of California courts will be examined in the second part of this video discussion. Final reminder: the contents of this video are for educational and informational purposes only. They do not constitute legal advice and are not a substitute for personalized guidance from a licensed attorney, familiar with your specific facts and circumstances. No attorney-client relationship is formed by watching, liking, commenting, subscribing, or communicating through this channel. Laws change over time and vary by jurisdiction. Do not act or refrain from acting based on anything in this video. Seek advice from a qualified professional in your jurisdiction. The creator disclaims any liability for loss or damage claimed to result from reliance on this material.